Okay, this short video is just going to take a look at how to get a divorce in Ireland. It's going to be obviously an overview of divorce law in Ireland, and it'll take a look at the requirements or qualifications in order to get a divorce and the procedure. It is only an overview. You do need to speak to a solicitor if you're thinking about getting a divorce or if you need more information. Now, my website there, familylawIrelandHQ.com, there is a link at the end, or the URL is on the last slide of this video. You can have a look at that website. There's quite a bit of information on the site about family law generally in Ireland, including divorce, separation, and so on and so forth. Let's have a look at divorce law in Ireland, and just as I say, it is an overview. You do need to speak to a legal professional. Divorce law in Ireland is provided for by the Family Law Divorce Act of 1996, and it allows both the Circuit Court and High Court to grant decrees of divorce. The Circuit Court has jurisdiction where the property concerned in the divorce has a market value of less than 3 million. So most people's divorce will be commenced and be dealt with in the Circuit Court. The grounds for divorce then under the Family Law Divorce Act of 1996, there are three main grounds. The parties must have lived apart for at least 4 of the previous 5 years. Secondly, there must be no reasonable ground or no reasonable prospect of reconciliation. And thirdly then, the court must make proper provision for the spouses and any dependent members of the family. So if the court is satisfied that all of these 3 conditions are met, then it will grant a divorce. And you'll see from these conditions that the question of fault on the party of one party or the other is really irrelevant. And the court isn't concerned about that, and that's why divorce in Ireland is described as no fault divorce. The notion of living apart then has been considered in some detail, because remember, you must have lived apart from your partner or spouse for 4 out of the last 5 years. However, the notion of living apart has been considered by the courts, and it has been held on many occasions that where a couple claim to be living apart, even though they are under the same roof, the court will only decide this issue based on the circumstances of each case. So, the courts have held that living apart doesn't necessarily require a physical living apart. You could be living under the same roof. They have held that living apart is really a state of affairs. In other words, a couple could genuinely be living apart. Their relationship could have broken down irretrievably. They could be living under the same roof simply because they can't afford 2 houses or whatever. So they could still qualify even though they're living in the same dwelling. The effects of a divorce decree then in Ireland are, well, firstly, the marriage is dissolved and both parties are free to remarry. The rights then of both parents to continue to be joint guardians of the children continue. And a divorced person is no longer considered to be a spouse and does not continue to enjoy the benefits of the Succession Act of 1965 or the Family Home Protection Act of 1976. There are also tax implications. You'd want to just discuss these with your accountant. A decree of divorce then does not prevent either spouse from being entitled to a widow or widower's pension, or the one-parent family allowance, or the deserted wife's allowance and benefits. The procedure then for divorce and judicial separation in the Circuit Court, as I've said already, the jurisdiction of the Circuit Court is up to 3 million. I think that should be 3 million there and not 5 million. All proceedings are commenced in the Circuit Court by the issuing of a family law civil bill. Every family law civil bill then must set out the relief being sought by the party and the grounds relied on for seeking that relief. The family law civil bill, along with a Section 5 or Section 6 certificate that must be supplied by a solicitor, an Affidavit of Means and an Affidavit of Welfare, where appropriate, in other words where there are small children or dependents, are filed in the Circuit Court office and then served on the other party. The other party then has 10 days within which to enter an appearance, and a further 10 days to enter a defence, as well as an affidavit of means and an affidavit of welfare. However, these time limits are unrealistic, and further time will actually be taken in practice. There's no difficulty with further time. The Circuit Court rules also provide for a sort of a fast-track divorce where both parties are agreed in relation to all of their reliefs being sought. This involves the respondent filing a consent defence and an application to court for a judgment by consent. There's also the possibility of simply obtaining a decree of divorce where no ancillary relief is sought. In other words, both parties just agree to go their separate ways and neither party is seeking relief from the other. Once all pleadings have been exchanged, a notice of trial is issued and served, and a date will be fixed for the hearing of the case. Just to go back to the question of an affidavit of means, where financial relief is being sought by one of the parties, the Circuit Court, or the court rules in general, provide for each party to file an affidavit of means. However, in Dublin, in where no financial relief is being sought, an affidavit of means is not required by the Family Law Office. An affidavit of means then is generally just a sworn document which is divided up into 5 lists, which set out the assets of the party, the income, the debts and liabilities, the outgoings, and any pension scheme which may exist. An affidavit of welfare then, on the other hand, must be sworn and filed where there are dependent children. The affidavit of welfare, it must give details of children born to the applicant and the respondent or adopted by them, and details of other children of the family or to which either of the parties stand in loco parentis. Interim applications then can be made by either party by way of notice of motion and affidavit. In other words, your divorce, if it was not very agreeable or satisfactory in terms of progression in time, then it may drag on for a while, and interim applications can be made to the court. The court can make any order then it sees fit as regards costs of either or both parties. My name is Terry Gorry. I'm a solicitor in Enfield, County Meath. That site there, the Family Law Ireland HQ.com site, if you take a look at that site, you'll find, as I say, quite a lot of information about family law in Ireland. I hope you find this overview of divorce law in Ireland useful. Thanks for watching.